ride the rest.
Oh, nice.
And all my stuff. Kind of hard to fit with it. All right, I've got somebody connected on, it says 1+ LE2127. Gentlemen, can you tell me your name, please?
Bernard Confletti.
Okay, sounds good. Your hearing is, I'm just gonna put you on hold for 1 second, Mr. Confletti, okay?
Sure, thank you.
Okay, Mr. Hunter, are you ready to proceed?
I am, yes, Your Honor.
Okay, and then Ms. Hunter, if you can hear me, I'm gonna need you to connect your audio, so you need to go into your Zoom app, and there's a button that'll, you have to press to connect your audio. Oh, you guys can go on the same, if you're in the same place, you can just use the same device.
Yeah, we're sitting next to each other, Your Honor.
Yeah, let's do that, because otherwise we're gonna have interference and echoes and all kinds of
Okay,
bad
come on over
stuff.
to this one.
I just closed it out.
Yeah, close that one out.
Okay, great. Yeah, when you have devices in rooms right next to each other, it doesn't work well with the electronics, so. Okay, so we'll go on the record in Hunter versus Hunter. This is case number 2311485. The record should reflect that we have both parties connected here by Zoom video. This is the date and time set for a final hearing in this matter. I do have a proposed judgment that's been submitted by the parties. And so were you guys ready to proceed with finalizing things today?
Yes, Your Honor.
Yes.
Okay, so I'm going to place you both under oath. I've got some questions that I need to ask each of you. The questions that I'm going to be asking you are the questions that I'm required to ask to establish the grounds for divorce under Michigan law. So if you could both raise your right hands, please. You both solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
I do.
Thank you. You can lower your hand. Use that here real quick. Okay, and do you guys know what is the status? I'm just looking at the file here. It looks like there was a friend of the court was going to conduct a child support review that's dated at the end of March. Has that been completed, do you know?
It has been completed, and we're trying to opt out a friend of the court.
Okay. All right, so just so you know, we're going to go through the proofs here today, but I will need to have that issue finalized before everything will be done, okay?
Okay.
All right, so Mr. Hunter, you filed the complaint for divorce in this case, is that true?
Correct.
At the time that you signed that complaint, have you been a resident of the state of Michigan for at least 180 days?
Yes.
Have you been a resident of Crawford County for at least 10 days?
Yes.
In that complaint, there's a statement that indicates that there's been a breakdown of your marriage relationship such that the objects of matrimony have been destroyed and there remained no reasonable likelihood that the marriage could be preserved. Was that true when you signed that complaint?
Yes, Your Honor.
Does that remain true today?
Yes, sir.
Okay. And there's one child that was born in the marriage, is that correct?
That is correct.
And under the judgment of divorce, you and Ms. Hunter would be sharing both joint legal and physical custody with essentially equal time between the two of you, or as you otherwise agree with your child. Is that correct?
That is correct.
Okay. And as I said, we'll still need to address the issue of child support once. Do you guys have a hearing date set for that to opt out, or do you know what the current status?
No, I don't believe we have a hearing date set. We got the recommendation in the mail, and that's, I think, about as far as it's gotten with it.
Okay, so again, I'm gonna ask you to contact friend of the court here yet this afternoon, so that you can get that process taken care of.
Yes, sir.
But we'll proceed with taking the proofs today. Okay, moving on. In terms of any assets or debts of the marriage, that's provided for here in these addendums that you guys have attached to the proposed judgment. Is that correct?
That is correct.
And you and Ms. Hunter have agreed on all issues with regarding dividing up the marital assets and debts.
Yes, Your Honor.
Mr. Hunter, under the judgment of divorce, you were not going to be receiving any alimony or spousal support. Is that correct?
That would be correct.
You understand that you would be waiving that forever and that you would not be able to come back later and ask the court for that?
Correct.
Okay, thank you. Ms. Hunter, have you heard all the questions that I've asked Mr. Hunter?
Yes.
Have you heard all of his answers?
Yes, I have.
Do you have any reason to believe that any of the answers he gave were untrue?
No, I don't.
And do you agree with the provisions of the judgment that provide that you're going to have essentially 50-50 custody of your child with Mr. Hunter, both legal and physical, or as you otherwise agree? Is that correct?
Yes, sir.
And do you agree that you and Mr. Hunter have reached agreement as to the division of all marital assets and debts?
Yes, sir.
And that the disposition of those assets and debts is included in this judgment that you've submitted?
Yes, sir.
Are you currently pregnant?
No.
Under the judgment of divorce, you also would not be receiving any alimony or spousal support. Do you understand that?
Yes.
And you understand that you would also not be able to come back later and ask the court for that?
Yes, I do.
Okay. All right, thank you. The court finds that the statutory grounds for divorce have been met by the testimony of the parties. Again, I can't sign the judgment today until you get the friend of the court matter taken care of with regard to child support and opting out. But we do have that judgment. So once you contact friend of the court and once you've taken care of that issue, then they can submit all the documents to me. I'll sign all of those. You won't need any more court dates in front of me. But just to make sure that you are both aware that the divorce won't be final until that last piece is taken care of, okay?
Yes, Your Honor.
Yes.
Okay, all right. Do either of you have any questions at all?
No,
No.
sir.
Okay, thank you. That's all for today, and you're both free to disconnect at this time.
Thank you.
Thank you.
All right, Mr. Conflitti, are you able to hear me okay?
Yes,
So I looked at because we didn't have a hearing for your case set on the docket today, so the court clerk just checked it with the file, and it appears that the state was taken down because the parties reached a settlement. The final order was entered on May 3rd.
okay. Yes, I didn't have confirmation that my sister's attorney had filed the paperwork, so I thought it would be better to show up here than assume that, he did and miss you in case it didn't happen. So I'm sorry if I'm wasting your time. I'd like to thank you though for allowing me to go to mediation. The people were very friendly, very nice, and they really, they made us able to speak to each other, my sister and I. So thank you. And again, I'm sorry if I didn't mean to waste your time here.
No, you're not wasting our time at all, and it's actually nice that you showed up just in case. A lot of times people don't show up even when they're supposed to, so it's
Right.
refreshing to have someone err on the side of caution. So I appreciate that, and I'm glad that that mediation process was good and worked well for you.
Okay, all right. Thank you ever so much. You have a great day.
Thanks, you too.
Yes, bye-bye.
Bye.
All right, let's turn this off.
I got some signed in. Ma'am, can you unmute, please? Hi, you're
Hi.
coming up on my screen as just Coach Katie. Can you tell me your name and what case you're here on?
Yeah, my name is Jennifer Tozer. Case number is 11608.
Okay, great, thank you.
I had to my computer, unfortunately the charging cord got destroyed by one of my dogs, so I'm using my daughter's computer.
Oh, that's okay. I just
Yeah.
I didn't see anybody named Katie on any of my cases.
Sorry about that. Yeah.
That's okay. And looks like I have Mr. Tozer connecting here, so it'll be just a minute.
Yeah, Friday. Yeah, last night, the other night I wrote down like maybe 20 minutes before I got soaked, and I'm like, okay, got 3 weeks before my first show, so like,
It looks like Mr. Tozer's having some problems connecting, so if you can just hold on for a minute, Tozer.
Yep, no problem. He's calling me actually.
Okay.
Hi. I don't know what your computer is like, so I'm using Katie's computer, so. Is there I had a little video icon that I had to click on. There you are, you're on there now.
Okay, then he just needs to unmute.
Can I hang up now?
I think so.
Okay, yeah,
All right.
I can hear you.
Okay.
Okay, great. So we'll go on the record now. This is Tozer versus Tozer, case number 2411608. The record should reflect that both parties are present today by Zoom video. This is the date and time set by the court for a hearing, and I do have a proposed judgment. Ms. Tozer, did you want the court to enter this judgment today and finalize the divorce?
Yes.
Okay, and Mr. Tozer, is that how you wanted to proceed as well?
Yes, Your Honor.
Okay, could you both raise your right hands, please? You both solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
I do.
All right, thank you. You can lower your hands. I'm going to be asking both of you a series of questions. The questions that I'm going to be asking are those that I'm required to ask to establish the grounds for divorce under Michigan law. Ms. Tozer, you filed the complaint for divorce in this case, and you signed that complaint. Is that true?
Yes.
At the time that you signed that complaint, had you been a resident of the state of Michigan for at least 180 days?
Yes.
Had you been a resident of Crawford County for at least 10 days?
Yes.
In the complaint, there's a statement that indicates that there's been a breakdown of your marriage relationship such that the objects of matrimony have been destroyed and there remained no reasonable likelihood that the marriage could be preserved. Was that true when you signed the complaint?
Yes.
Does that remain true today?
Yes.
Are there any children who are under the age of 18 that were born to or adopted by you during the marriage?
No.
Are you currently pregnant?
No.
Under the proposed divorce.
I'm sorry, I didn't hear that part.
Yeah, I'm just getting some feedback. Okay, it seems like it's gone away now. Under the proposed judgment of divorce, Ms. Tozer, excuse me, you're going to be receiving alimony in the amount of $2,000 per month, starting on May 15th. And that will continue for as long as Mr. Tozer owns St. Helen Family Dentistry. Is that your understanding?
Yes.
And under another paragraph in that section of the judgment, it provides that that is final, binding, and non-modifiable. That means that as we go forward, the court would not be able to adjust that amount up or down or the duration of that amount. Do you understand that?
Yes.
In other words, it'll be $2,000 per month as long as Mr. Tozer owns St. Helen Family Dentistry, and that will never change.
Correct.
Okay. All right. And the two of you have agreed to divide up the assets and debts of the marriage as reflected in the property settlement agreement that's attached to the judgment of divorce. Is that correct?
Yes.
Okay. And I have here that you signed that on March 14th of 2024. By signing that document, does that mean that you've read that document and then you agree to abide by its provisions?
Yes.
Are you asking to have your last name changed?
No.
Okay, thank you. Mr. Tozer, have you heard all the questions that I've asked Ms. Tozer?
I have.
Have you heard all of her answers?
I have.
Do you have any reason to believe that any of the answers that she gave are untrue?
I do not.
And you understand that under the judgment of divorce, you would not be receiving any alimony or spousal support.
That is correct. The only correction I have there is that alimony is for 4 years only, not after that period of time.
Okay.
And
Well,
that's in the property settlement.
oh, okay. So there's, all right, hold on a second.
It's not alimony, it's spousal support and for the equity of the property settlement. First year would be considered alimony, but after that, it's not.
Yeah, it's on page 4. Number 13.
Okay.
That helps you at all?
Yep. I see that now. So, under the judgment of divorce, which is even though the property settlement is attached to the judgment, they're really two separate documents. So, and if they're going to have provisions that cover the same asset, then they need to, they need to be, they need to read the same. So, I mean, there's a couple different options how we can proceed. If you want me to edit the judgment, page 204, where it's states spousal support and alimony. I mean, I can adjust that, but right now those are two really different things and would have different impacts legally to both of you. So can't have inconsistent provisions, I guess is what I'm saying. So how do you both want to proceed with that?
I'd say amend the consent so it matches the property settlement. Yeah.
All right, Mr. Tozer, do you have any objection to that?
I do not.
Okay, so what I'm gonna do is in the judgment where it says spousal support or alimony, and that's on page 204. I'm gonna provide where it says, it is further ordered in the judge that the plaintiff shall receive alimony or spousal support in the amount of $2,000 per month, starting May 15, 2024, for as long as defendant owns St. Helen Family Dentistry. I'm gonna delete that entire paragraph and add in plaintiff shall receive spousal support pursuant to paragraph 13 of the property settlement agreement.
Okay.
Okay, Mr. Tozer, do you have any objection to that?
I do not, as long as it follows the property settlement agreement with regards to that particular section, no.
Okay. All right. Okay. And Mr. Tozer, with regard to that property settlement agreement, you have reviewed that and you also signed that dated March 14th of 2024. Is that correct?
That is correct.
And by signing that document, is it your intent to agree to all the terms and abide by those in that property settlement agreement? All right, thank you. Okay, the court finds that the statutory grounds for divorce have been met by the testimony of both parties. I've reviewed the proposed judgment, find that it's equitable and otherwise contains all the provisions required by statute and court rule. The court will grant the divorce. I've signed that judgment, and I see that you provided for copies to be sent out. Ms. Tozer, do you have any questions at all?
No, I do not.
Mr. Tozer, do you have any questions?
I do not, Your Honor.
Okay, thank you. That's all for today's hearing, and you're both free to disconnect at this time.
Great, thank you.
Thank you, sir.
Ms. Whitman, are you able to hear me okay?
I am, Your Honor. Thank you.
Okay, and just waiting for Ms. Bailey Quick to connect here.
Oh,
Okay, we have everybody connected. We'll go on the record now. This is Swander versus Averill, case number 2010818. If I could have both counsel put your appearances on, please.
Melissa Whitman here for Ryan Zaverill.
Ms. Bailey Quick, you're muted.
Sorry, Miranda Bailey Quick on behalf of Ellie Swander.
Thank you. The record should reflect, we also have Ms. Robinson from front of the court present here in the courtroom today. This is set for a status conference in this case. Frankly, I mean, I took a look at the file. I'm not sure exactly where we're at with this. So Ms. Bailey Quick, I guess on behalf of plaintiff.
Yes, so we were before you on the issue of arrearages, and right after that hearing, I prepared the order and sent it to front of the court. They sent back suggestions regarding changes. I made those changes and sent them off to Ms. Whitman, who then shared them with her client. And then approximately a month later, I received an email from Ms. Whitman, which I didn't realize I received until she followed up this week. And I then circulated that order. She approved that. I then circulated that order and I sent it off to Ms. Robinson today, earlier with everyone's signatures.
Okay, Ms. Whitman.
Yes, yeah. From my review, I approved the order back in March and it just never got sent through. So we just, and thank you to Attorney Bailey Quick for circulating that so quickly, and it should be all set.
Okay, Ms. Robinson.
I have not received a copy of it yet
Okay,
to review it.
okay. It sounds like it just got mailed yesterday, so
Okay,
you just need to wait until you get it.
sure.
Okay.
Yes, I
No,
would like to.
I just to clarify, I emailed it into the friend of the court email earlier today after obtaining everyone's signatures.
Oh, it wasn't given to me, Your Honor. I didn't check the email
Okay,
recently
okay.
today, so
This-
I apologize.
Oh, that's all right. Is there anything further that we need to do with this matter then, now that it's submitted?
I
At
don't-
this point?
I don't believe so.
Okay, and I'm assuming Ms. Robinson, once you do have a chance to look at that, you'll let them know if there's an issue.
I did have a question though.
Okay.
When I was looking back at the last one, it had mentioned something about birthing expenses, something about that amount doesn't include birthing expenses or monies that are payable to the state. Are there any birthing expenses that are still outstanding? Because the friend of the court doesn't show anything being owed to the state of Michigan. It was my understanding that the birth was paid through private insurance company. Is that correct?
I'm not sure if it was through a private insurance company. There was previously birthing expenses, confinement expenses in the original front of the court order. And it is my understanding from a thorough review of all of the hearings in this case, when I wasn't involved, is that my client, when the case was opted out, paid all of the fees that was owed on behalf of Mr. Zaverill to the state of Michigan. So up until they opted back in, all of the fees were paid to the state.
So does that mean that there is nothing outstanding right now in that case?
I'm not sure I understand the way you put that. Because the arrears order only addressed the child support amount. It did not address the birthing expenses.
I guess my question is the understanding that she would be repaid the birthing expenses as part of the arrearage or not? I guess I agree with Ms. Robinson. It's a question that we need clarification on.
That was part of an original order. We didn't, as far as I understood it, we didn't touch or address that. We only addressed the issues of arrearages.
But there's language in the current order that we just submitted that it doesn't address, right? It carves out, those are separate. But now looking at separate, it shouldn't be an issue anyway because there are no outstanding expenses.
There are no outstanding expenses to the state, but there was an order for confinement expenses.
Okay. And I don't know what the order said, do you?
What's that?
I guess Ms. Robinson is asking, she doesn't seem to be aware of what that previous order said that would be preserved, I suppose. Is that, maybe I'm misstating, Ms. Robinson, your question?
It's my understanding that when the parties opted out of friend of the court, then friend of the court was no longer keeping track of any arrearages or anything like that. So now that the parties opted back in, the friend of the court would need a new amount to put back on. So if there are outstanding birthing expenses that are still owed to Ms. Swander, then we would need to know what those are so that we can put those arrearages back on our system. Just like you're asking that we put that $15,000 figure on as an arrearage in child support, we would need to know if there's anything still owing in the birthing category. And then we would need to know that amount to put that amount back on.
That makes sense.
I'd have to go back through the file and see what that is. There was no payments ever made. So whatever that number was in the original order, that's what the confinement expenses are.
Okay, but then we would need to have that in the form of an order to put that back, to put that amount back on.
Okay, so then it sounds like Ms. Bailey Quick and I should talk about that and possibly submit a supplemental order.
Can you do that within the next 30 days?
Yes, we should just get it taken care of. Yes.
Okay, so we'll put a 30-day time limit on that and then to submit that to you, Ms. Robinson.
Thank you.
Okay, anything else that you had?
Not that I can think of.
All right, council, anything else that either of you want to address while we're on the record today?
I don't believe so.
No, Your Honor.
Okay, thank you. Everybody on this file is free to disconnect at this time.
Thank you.
Thank you.
Thanks.
Hello,
Hi there, can you tell me your name, please?
Michelle Ochoa.
Okay. And if that's you, Mr. Ochoa, you're gonna need to go into your Zoom app. You need to connect the audio on your Zoom app, please. Okay, and now you just need to unmute.
Hello?
Thank you. Are you Mark Ochoa?
Yes, I am, sir.
Okay, great. We're on the record in Ochoa versus Ochoa. This is case number 2411615. The record should reflect both parties are present here today. I have this set today for entry of a final judgment of divorce. Ms. Ochoa, is that how you wanted to proceed today?
Yes, Your Honor.
And Mr. Ochoa, is that how you wanted to proceed?
Yes,
Okay, can you both raise your right hand, please? You both solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
I do.
Thank you. You can lower your hand. I'm going to ask both of you a series of questions. The questions that I'm going to be asking you are those that I'm required to ask to establish the grounds for divorce under Michigan law. Ms. Ochoa, you filed a complaint for divorce in this case, and you signed that complaint. Is that true?
Yes.
At the time you signed that complaint, had you been a resident of the state of Michigan for at least 180 days?
Yes.
Had you been a resident of Crawford County for at least 10 days?
Yes.
In the complaint for divorce, there's a statement that indicates that there's been a breakdown of your marriage relationship such that the objects of matrimony have been destroyed and there remained no reasonable likelihood that your marriage could be preserved. Was that true when you signed the complaint?
Absolutely.
Does that remain true today?
Yes.
Are there any children who are under the age of 18 that were born to or adopted by you during the marriage?
No.
Are you currently pregnant?
No.
Okay, under the proposed judgment of divorce, you would not be receiving any alimony or spousal support. Is that correct?
No, we actually had spousal support dropped off the paperwork added for $500 a month.
What you have is what
When did you drop that off?
That was dropped off about 40 days or 45 days after the filing of the divorce.
Mr. Ochoa, are you, oh, I see, okay.
I don't know if it's a judgment.
Mr. Ochoa, are you agreeing to pay spousal support in this case?
Yeah, that was $500 a month
Okay.
for 2 years.
Okay. Okay, all right. And then I have here an addendum which sets out the assets and debts. And did you both want me to attach that to the judgment of divorce?
Yes.
Yeah, that's fine.
Okay. All right. And in terms of the assets and debts of the marriage, Ms. Ochoa, do you agree that you and Mr. Ochoa have agreed on how to divide up all of those things?
Yes.
Okay.
Yes.
All right. And you don't own any real estate or real property together, Miss Ochoa?
No, we do not.
Okay. All right. Mr. Ochoa, have you heard all the questions that I've asked Miss Ochoa?
Yes.
Have you heard all of her answers?
Yes.
Do you have any reason to believe that any of the answers that she gave were untrue?
No, they're all true.
Okay. And again, you're agreeing to pay that spousal support at $500 a month for 2 years.
Yes.
And you understand that you will not be receiving any kind of spousal support.
Yes, I understand.
Okay. All right. Miss Ochoa, are you asking to have your last name changed?
I did not, no.
Okay. All right. The court finds that the statutory grounds for divorce have been met by the testimony of the parties. The court will grant the divorce. I'm signing that judgment with today's date. If either of you need a copy of that for your records, you can get that here at the clerk's office in Crawford County. Ms. Ochoa, do you have any questions at all?
No, I do not.
Mr. Ochoa, do you have any questions?
No, I do not.
Okay, thank you. That's all for today, and you're both free to disconnect at this time.
Thank you, Your Honor.
Thank you.
Thank you. All right, Ms. Alspa, oops, I just muted you. Sorry about that. You're signing in on Ally Bank versus Kevin Whitfield, is that correct?
Yes, Your Honor, I represent Ally Bank.
Okay, and this is your client's motion for entry of a default judgment. And
Yes.
Order to seize property. This was set for 2:30 today. It's now 2:38. Mr. Whitfield and no one on behalf of Mr. Whitfield has either signed in on Zoom or appeared here at the courthouse. It does appear that he was properly provided notice of the date and time of today's hearing. Was there anything that you wanted to say in support of your motion for default judgment?
Nothing in addition to the motion, Your Honor. I rely on the motion.
All right. The court finds that it would be appropriate. I've had a chance to review the file. And based on the information contained within the file, as well as Mr. Whitfield's failure to appear today, the court will grant the motion. I'm just looking through here. Did you submit a proposed judgment?
Yes, Your Honor. It's under Exhibit E.
Oh, exhibit. Okay, great.
Should be at the end of the packet. Last 3 pages.
Okay, got it. Okay, I've separated that out. I will sign that judgment with today's date. Is there anything else that I can address for you on the record here today?
Nothing else, Your Honor. Thank you.
Okay, thank you. That's all for today's hearing, and you're free to disconnect. And
All right, have a good day.
Thank you.
Bye-bye.
Also, the court's afternoon docket. The court will be in recess until 9 a.m. tomorrow.
Judge, is that a closing order?